Hi, everybody. How y'all doing? You all having a good con? Everybody good? Everybody happy? This is a big room. You all should move forward. This is a really good talk. You should move forward so you can hear and see and stuff. And there's no splash zone, so you don't have to worry about getting wet. So move forward, and it also leaves room for the slackers who are coming in late. This is When the Cops Come A-Knockin' in Mandalay EF with Jennifer Granick and Riana Pfefferkorn. And before we begin, I have a few brief notes, and you've probably heard this about 1,000 times now. Stop by the business hall, located in Bayside AB. The Black Hat Arsenal is upstairs on level 3 in the Palm Foyer, and as is the Arsenal reception at 5 o'clock. This is the last day to pick up swag and merchandise, so if you haven't done so, go to the Black Hat bookstore in the Black Hat swag area. And make sure to visit the Kali Linux lab in Mandalay Bay A. Also, now is a good time to put your phone on vibrate, because if it rings, we are all going to point and laugh at you. So don't be that guy. All right, Jennifer Granick and Riana Pfefferkorn.
Hello, everybody, and thank you for coming. Can you guys in the back hear me over there? No? Okay. I'll try to get how about now? Seems better. Okay, I'm Jennifer Granick. I'm the Director of Civil Liberties at the Stanford Law School Center for Internet and Society.
I'm Riana Pfefferkorn. I'm the Cryptography Fellow at Stanford CIS.
And this is our talk, When the Cops Come A-Knockin', about technical assistance. So basically what we're going to discuss today is identifying the legal and business issues that come up when police come to your company and ask for technical help in collecting information about your customers. So what we're not going to talk about today is the law that governs when you're obligated to turn over user data. In other words, just pure surveillance law. There's a lot of other talks about that, including some by me, and we're just going to assume in this case that the government has judicial authorization to get data, but is coming to your company and asking for technical assistance. And we're going to talk about the legal regime that arises under traditional law enforcement authorities for regular police investigations. We're not going to talk about foreign governments or intelligence agencies. Those situations are different, and they're also rarer. And then finally, I have to give you the caveat, which is that this is not legal advice. We're not your lawyer, unless you know alternatively that we are. But if you do need legal advice about this issue, feel free to contact us after the talk is over. And if we can't help you, we can help put you in contact with somebody who can. So under the traditional technical assistance way that things go, there's a provider, and it used to just be a local phone company. And the provider would be served with, the law enforcement would go out and get a court order. And the court orders are obtained ex parte. That means that there's no other entity in the room to condition or argue against the government's case. They'd say, we need this data and we need help to get it. And the judge or magistrate will sign the order, and the order will say, this surveillance is authorized, plus there's order for technical assistance. And the technical assistance would occur under either a statute that explicitly authorizes it, like the pen register statute, or the Wiretap Act. We'll talk more about that. Then the government or the government agent would take the order over to the communications provider, the local phone company. Now, from the provider's point of view, once they get the order, they review it, and then the kind of technical assistance that traditionally was involved was something that was very simple. Basically, phone companies would control the computer interface that was capable of sending the relevant data, either phone numbers dialed or the actual audio of phone calls, over a leased line that law enforcement controlled to a law enforcement monitoring facility. So in other words, the kind of technical assistance that was involved was something basically like flipping a switch to send data that the phone company already had access to over the leased line to law enforcement.
So what we're interested in talking about today is more novel forms of technical assistance, compelled decryption of data, inserting backdoors, being forced to hand over your encryption keys, and so forth. And these are all things that law enforcement has suggested that it can force providers and companies to do. But can it actually do that? There's no definitive answer. The courts haven't really clearly said one way or the other.
So ultimately, the upshot of this talk is that while technical assistance demands aren't new, law enforcement has gotten a lot more aggressive. And the reason they've gotten more aggressive is because of encryption. The FBI and police agencies see encryption and they think to themselves, or the increased use of encryption, and they think to themselves, here's information that 5 years ago we might have had access to, but now we're going to decreasingly be able to understand it. And they call this problem the going dark problem and say, this is a major emergency for law enforcement investigations. Now, the civil liberties response to that is that actually there's more information about us available than ever before because there's sensors everywhere, online and increasingly offline as well. And so rather than there being this great decrease in the amount of information available for crime fighting, there's actually a gigantic increase. And all encryption is doing, other than securing people from attackers and identity thieves and that sort of thing, is removing a fraction of that massive amount of new information from law enforcement. But as part of this Going Dark campaign, law enforcement has said, okay, we're going to go to internet companies and we're going to ask for their help in subverting encryption so that we can assure that we have access to this information. But the legal regime for doing this is very uncertain because it's very new and it's very different from the traditional model. So the ultimate message that we want to leave you guys with is that the law is uncertain here. We'll explain it as best we know what it is, but that companies can and should push back. I need to give you a little bit of legal background about a special statute, which is the Communications Assistance to Law Enforcement Act, or Kalia. Because all of this debate takes place against the backdrop of Kalia, and what does Kalia mean? The thing about Kalia is that the statute mandates wiretapability for certain regulated entities. Now, those regulated entities are the traditional telephone company and things that stand in as replacements for traditional telephone service. So interconnected VoIP and internet broadband. And then the Federal Communications Commission could add to that list over time if it wanted to. But it very explicitly does not apply to information services, which is basically the rest of the internet. And what it says is if you are one of these categories of regulated entities, you have to follow a particular technical standard to ensure ease of wiretapability. But Kalia also talks explicitly about encryption. And Kalia says that even regulated entities do not have to be able to decrypt unless they both provide encryption and possess the information necessary to decrypt. Okay? So what does the fact that Kalia has to say this mean for non-regulated entities? Does anyone else have to decrypt? And the upshot of Kalia is that no one is obligated to build in decryption capabilities. But if your service is designed in such a way where you have data and it is encrypted and you can decrypt it, then we have to ask whether, despite Kalia, there's any other legal authority out there that can force you to do it. If there's no statutory authority that compels this assistance to law enforcement, then you don't have to assist. So the statutory authority that specifically addresses this for non-regulated entities are the Pen Register and the Wiretap Act. And each of these has a specific provision for technical assistance, and they're very similar. And basically what they say is that a provider or other person, which can be read pretty broadly, shall furnish technical assistance if it is necessary, if they can do so unobtrusively, and with a minimum of interference. So those are the statutory factors we look to if the government comes to you and says, you have to assist me under either Pen Register or Wiretap Act. Then there's another statute called the All Writs Act, or AWA. We'll be referring it to it that way. And, oh, I'm sorry, I'm taking your slide.
That's okay, go ahead.
I'm a little greedy, I apologize. The AWA is really old. It predates the Fourth Amendment, and one of the questions is, can this statute that's much more general and isn't specifically about technical assistance be stretched far enough to cover these modern technologies?
So you're here to learn about the history and the law that applies in this area. And as said, this is a very unsettled legal landscape. You need to be prepared to potentially have to handle these kinds of technical assistance demands that have come in. And that includes not just familiarizing yourself with the law, but also having a game plan in place and knowing your product or service. So when it comes to knowing your service and how it works, knowing your user data practices is really key. Now that's important for a variety of business reasons and legal reasons outside the context of technical assistance demands. But in this particular context, it's important because you can't be compelled to hand over data that you don't collect, data that you haven't retained, you expunged it, it's already gone, or data that you don't have any access to. So if you hold user data but it's encrypted, you also can't be compelled to decrypt it if you don't have the capability to do so. If you do, then you ask whether Kalia is applicable to you, but we're not really going to focus on Kalia. We're assuming that most of your companies are information services that are not covered by Kalia. You need to be thinking through these design decisions in the context of US law, but also be aware that you might receive demands from other foreign authorities or intelligence services, especially if you have users in other countries. You should always have good reasons for the privacy and security design decisions that you make. All right, so who are you going to call? You have a phone tree and you have a plan in place for who to call if your servers catch fire or fall over. You need to do the same thing to be prepared for when law enforcement comes calling. So that means having a game plan in place beforehand. That's key, because if you figure that out now, you'll be prepared when the cops actually come knocking. And that's important because things are going to move very fast if you do get a technical assistance demand. You're going to be under a lot of pressure from law enforcement to comply quickly. They might try to get the court to fine you hundreds of thousands of dollars per day that you're not complying. And without a game plan in place, you might end up disadvantaging yourself in protecting your business and protecting your customers. So you need to get a lawyer. You have to have a lawyer who has experience in handling government demands. The person who did your real estate lease for your office, your patent lawyer, your employment lawyer, those aren't the right people to call. And as Jennifer said, you can always contact us at Stanford if you need a referral. Your decision should also involve your CISO. They aren't just thinking about the particular user account that's at stake in a particular demand. They have the entire system security to think about.
So, so often in our area of the law, there are no clear answers, but we always try to provide people with actionable kind of legal cheat sheets. So that's what this slide is trying to do. These are the topics that we're going to go through today. There are answers for some, but you'll see that a lot about the law is unknown. We're going to try to talk about that, the parameters of what's unknown and the areas where you're definitely in the right.
So what about decryption of data that's held by a provider? Now I'm using provider pretty broadly here. That can mean an email service, that can mean a social media platform, that can mean an instant messaging tool, and so forth. Now the general practice here has been that if the provider has the data and has the capability to decrypt it, then they generally do so pursuant either to the Pen Register or Wiretap Act, an order that encapsulates those, or to an order that combines the Stored Communications Act, which affords the government, under certain circumstances, access to the contents of communications held in electronic storage, with either an express or implied All Writs Act aspect to it. But is that actually correct? Is that actually right under the law? We don't really know, but this has been sort of the de facto law that's been created by convention. We haven't seen providers openly challenge the scope of these statutes in this context, but we know that they generally go along with these kinds of orders because this kind of compliance is considered pretty run-of-the-mill. So, what if the data isn't held by the provider, but is instead held on a user's device? That's where there isn't really any direct statutory authority that's on point to compel you to decrypt data that you don't hold, but that your user holds. The federal government has tried to use the All Writs Act. I want to emphasize here that there are no standalone All Writs Act orders. You have to have an underlying surveillance order, search warrant, and so on. Now, we know that courts have been signing these orders without any real analysis for the most part. and that companies like Google or Apple haven't really been challenging them. There have only been 2 published opinions that have come out publicly that included any particular real legal analysis to say, does the All Writs Act actually permit this kind of compulsory decryption of data on devices? One court, Judge Gorenstein in one part of New York said, yes, it can. Another judge, Judge Orenstein in a different part of New York, said no. But most of the orders that come out tend to have no legal analysis whatsoever, and they're usually under seal. So I mentioned Judge Orenstein. He's a federal magistrate judge in Brooklyn. This was a case involving Apple and the FBI prior to the San Bernardino case that I'll discuss momentarily. And Judge Orenstein was the first court to actually ask Apple's opinion as the company that's being requested to comply with this kind of demand. What does Apple think? Does Apple actually believe that it can be forced under the All Writs Act to provide this kind of assistance? And Apple said, no, we don't think that we can. And the court agreed and said, okay, law enforcement can't compel you to decrypt device-held data, even if it doesn't really require you to do that much. In the case that was in front of the Brooklyn judge, the phone at issue was running iOS 7. Apple at the time had the capability to bypass the passcode on that phone and extract certain categories of user data. So it wasn't like it was a huge ask in terms of technical requirements to make them do this. But the judge still said no, the All Writs Act does not authorize that. The government appealed, but they dropped the case later on when the defendant, whose phone it was, magically remembered his passcode. And in the context of that, Apple's been re-engineering its phones to make it more difficult for Apple itself to decrypt data held on devices. Can the government compel you to create entirely new software to assist law enforcement? That's the San Bernardino Apple versus FBI case that we all saw in the front pages earlier this spring. And that is a situation where, what if you don't have the capability to decrypt? As I mentioned, Apple has been re-engineering its phones. It didn't have the capability on this particular phone. In the Apple versus FBI case, one of the San Bernardino shooters had gotten a work-issued iPhone. The FBI got a warrant for it, so there wasn't any privacy issue there. But the phone was locked and was running iOS 9. Now, from iOS 8 onward, Apple no longer has the capability to bypass the passcode on it. The device is encrypted by default. So the FBI made a very aggressive demand saying, we want to dragoon you, Apple, this outside company, into the service of law enforcement by compelling you to write custom software that would undo several different security protections that Apple had included on those phones for its users. And the FBI asserted that it had authority to do this under the All Writs Act. And in specific, under a Supreme Court case from 1977, the New York telephone case. Now, in that case, the government successfully used the All Writs Act to force a phone company to collect pen register data. Phone numbers going outbound, phone numbers coming inbound, that kind of thing. But now, 4 decades later, the FBI is saying that that case from 1977 means that they can make Apple unlock phones where Apple just happened to have written the software. But that's a really big technological leap from just gathering and handing over pen register data. For one thing, cell phone manufacturers, unlike the phone company, don't have any ongoing connection to the data that's on the user's phone. Apple just made and sold this phone. That was really the end of the story. Also, you have to ask, is it necessary for the company to help out? In Apple's case, there's third-party forensics tools out there, some of which have been talked about in these very halls to help get access into a phone. Why do you have to go to Apple and force them to rewrite their software to do that? And finally, you want to ask, is it burdensome on the company to comply with this kind of demand? And that doesn't just mean technical burden, but business reasons as well. We don't really know, even after this case was resolved, what necessarily counts as burden. Does that just mean engineering time, or does it include lost profits, your business reputation, your business goodwill? And we also don't necessarily know whether burden includes risks to people other than the company, like your customers, like the greater security ecosystem on a whole. Now, Jennifer and I filed a friend of the court brief in the San Bernardino case on behalf of several iPhone security and applied cryptography experts, where we argued that the existence of this weakened version of iOS would harm iPhone users around the world because other governments are all going to want one too as soon as the FBI gets a copy. They might seize it, demand it from Apple, and if it's out there, there's a risk of misuse, especially by oppressive governments that don't respect human rights, getting hacked, of getting stolen, and those aren't really accounted for well in the All Writs Act. Ultimately, because the government was able to buy a third-party exploit for hundreds of thousands of dollars, there wasn't a legal decision in the San Bernardino case that actually says how far the All Writs Act goes. So that question is still pretty unsettled.
Okay, so what about if you sell a product or you have software that enables turning on audio or video in one of these Internet of Things kind of devices? Believe it or not, this was actually a legal case back in 2003. And it involved a system in a car that had audio. So we don't know the name of the company. We don't know the name of the company because it's under seal, but it was like OnStar. And the question was, the FBI found out that these mobsters were discussing their criminal activity in the car, and they wanted the OnStar-like service to turn on the microphone so that it could hear the mobsters when they're in their car talking privately. And the question was, could they do that? So they said, okay, it's a wiretap act because you're listening to a real-time communication, real conversation. Does the technical assistance provision of the wiretap act allow the government to compel this company to turn on the microphone? And there were three main issues in the case. Other person, was it necessary, and was it unobtrusive with a minimum of interference? And what the court said in this case was, well, technologically, the companies presented us with information that in order to do this, to turn on the microphone, it would utterly disable the system in the car. So that if, for example, they tried to use the service that calls 911, wouldn't work. And so, therefore, it's not a minimum of interference. It disables the service, so we're not going to allow it. It asks the company to do too much, and it goes too far. Well, the question is, that was a technically related finding based on the operation of this particular service. Have there been other court cases, other petitions, to turn on audio or video in consumer goods in order to conduct surveillance? And the answer is, we don't know. And it's increasingly important because more and more of our consumer goods that we have in our house are audio and video capable, to the point where for smart TVs, companies are now starting to warn their customers that their conversations in front of the TV could be captured and sent to the company. And so people should be very careful not to have confidential conversations in front of the television. Riana and I are working at Stanford to try to force courts to disclose whether they've been granting these kinds of orders. So you can keep up with us if you're interested in that effort. What about disclosing encryption keys? Now, I said normally the way that this works is the government will come to a provider and say, decrypt this information you have for me, and if the provider is able to do it, they decrypt it and they turn over the plain text. But what happens when that doesn't work? And the government's decided, well, we want the encryption keys. Obviously, having a service's private encryption keys enables all kinds of mischief, from man-in-the-middle attacks to loss of the key and interception by identity thieves and other intruders. So can this very dangerous kind of thing take place? And we actually have a case, which is the Lavabit case that took place a couple of years ago. In which this was the very question that the court, trial court, and then the Fourth Circuit had to answer. Ladar Levison, who's the founder of Lavabit, is actually going to be at DEF CON talking about his experience being the target of this surveillance effort. So I'm not going to get too much into the details of it because Ladar's going to tell it better, and I think it's going to be an awesome talk. But the ultimate legal issue that he had to face was the government wanted to get his key so that they could decrypt email transactional information. And Ladar's response was, well, if I give you that, not only are you going to be able to go after the person who's your target, at the time suspected and then later proven to be Edward Snowden, you're going to be able to decrypt the transactional information, private conversation data, for all of my users, and I just can't do that. I can't turn it over. And what the FBI did was they used a couple of different legal procedures in rapid succession in order to try to force Lavabit to turn this information over. They used the pen register statute's technical assistance provision. and said, that you've got to provide us with the technical assistance necessary, and this is necessary. And then they got a search warrant under the Stored Communications Act saying, we want you to turn over the key. And Ladar dragged his feet and delayed and eventually closed down the business. And the case got appealed to the Fourth Circuit. And so one of the issue before the Fourth Circuit was, can the government seize your private decryption key from your service? And the Fourth Circuit didn't decide. For a variety of procedural reasons, the court didn't consider the underlying legal argument fully. But it's a real stretch because traditionally, by which I mean all the time, search warrants can only be used to seize the contraband of a crime or something that's evidence of a crime or that kind of thing. It's not a tool that you can use to seize something innocent like a key that might be useful in a crime investigation later on. But Lavabit faced this litigation at great business expense, and we still don't have any case law on this. So another thing we need to learn about. What about pushing out a malicious software update? This is something that, for people who followed Edward Snowden disclosures, really interesting aspect about conducting surveillance by forcing spyware onto computers. One of the ways to do this is, depending upon what the service is, the company that pushes out the software update has to sign it with their signing key. And so can they do this, and can they force a company to sign the software? This was an issue in the San Bernardino case. Well, there's really, for the same reasons we've discussed, there's no direct statutory authority that allows this. There's obviously a real danger to the security ecosystem, which the statutory rules don't really contemplate and show how we would consider that. But in addition, there's a very strong First Amendment argument against doing this. And the First Amendment argument is that the First Amendment does not allow the government to compel you to speak. And that by forcing you to use your private key to sign software, they're basically forcing you to make an attestation that this software is safe and good for you to run. Now, we haven't litigated this. There's not a real clear answer in the law. But if you're ever asked to do something like this, you have a lot of strong legal arguments to say no. And then what about backdoors? It's not a specific surveillance thing right now, but the government comes to you and says, you want to build this thing securely, but we don't want you to do it. We want you to make sure that you're always going to be able to help us out, your friends in law enforcement. Build a backdoor in here to ensure that we'll always be able to decrypt if we come to you. There is no obligation to build in backdoors. And in fact, there's not really an obligation, if you look at the statute, there's not really an obligation under Kalia for entities to build in decryptability either. They only have to be able to decrypt if they both provide the means and have the keys. So there is no legal obligation in the law to put in backdoors for prospective surveillance. The upshot of Kalia and the statutory authorities is that end-to-end encryption is legal, period.
Yes, good applause point. But if you do build in a backdoor, they will come. If you build in your own tools for access to encrypted data, don't be surprised if law enforcement wants to use those tools for their own purpose. Now, there's a variety of totally legitimate reasons for which you might want to build in access to encrypted data, troubleshooting, customer data recovery, and so forth. And this highlights a tension between different values that you have in terms of providing a good service to your users, in terms of security on the one hand and usability on the other. You want to be able to provide your users with strong encryption to protect them against attackers, but your users shouldn't end up losing everything just because they forget their passcode and you have engineered your system so strongly that neither you nor your users now have any way to get into that information. But the upshot here is that if you retain some access to user data to help your users, law enforcement is going to want to use that same tool to surveil your users. Now, finally, what if the government wants to install its own software or hardware on your system so that it can directly access user data? In some cases, the government can definitely compel company assistance with installing wiretaps, installing pen registers, but when it comes to anything beyond that, the law is not clear on whether you can be forced to use a government's hardware or software to accomplish data collection. And in fact, this is really what Kalia as a statutory scheme was passed to avoid, to clearly set out in the law that companies are required to follow certain standards in terms of making their systems wiretappable. It's obvious that there are a lot of dangers inherent in doing this because there's security risks, there's vulnerabilities, you might get hacked later on, that access might get misused by law enforcement later on, so you should never do it without C-suite approval, general counsel involvement, and with so many downsides and no clear legal basis, very comfortable, very solid ground saying no, there is no legal requirement for you to do this.
So legal summary. Historically, there's very little that companies were obligated to do under these technical assistance measures. But the government asks. Remember that requests are not orders. Orders only come from the court. And even court orders are not the law. This is a very unsettled area of the law, and judges in these ex parte hearings can sign things that are not substantiated in the law where they can't be enforced. That means that companies need to exercise their independent judgment. You should feel free to embrace encryption, and when those cases come up where the government comes to you for technical assistance, remember that the legal issues are appropriateness, necessity, burden, security, and those are things you're going to have to consider.
So what do you do once you actually have gotten a technical assistance order? Well, we've prepared some handy checklists for you. Read over the order, make sure it's signed by a judge. You don't have to comply with something that's just an informal request rather than a court order for sure. Make sure that the police are only asking for what it says in the order that you have to do. You don't have to do anything that isn't spelled out in the order. So if the police are asking you for more, you can tell them to go back to the court and get an order that expressly authorizes whatever it is that they actually want. It's entirely possible that they'll just go away and not come back, or at least wishful thinking, but sometimes that happens. They don't necessarily always come back. And you should also definitely ask for an opportunity to be heard by the court, to put your point of view forward in front of them. Like I said earlier, it took until last fall with that one judge in New York to even say to Apple, hey, you've been getting these orders for a while, what's your opinion on this? On top of that, figure out what it is exactly that the order would require you to do. We've discussed that there are some forms of order that are pretty routine. So if an order asks you to turn over clear text or decrypt information that you have and have the capability to decrypt, recipients of those orders generally comply. Whether the government is actually entitled to clear text or not is a matter of surveillance law. That's beyond the scope of this talk. But if the government is entitled to clear text, then requesting this particular type of technical assistance to hand it over is pretty run-of-the-mill, and companies do it. If there's a gag provision in the order, try and push back against that. You're going to want to notify your user that their data was being handed over to the government. If you're denied upfront notice to the user, that's fairly likely, at least push for delayed notice later on to tell them after the fact. And if you get an order that's novel, that's not just hand over clear text or decrypt data that you have the capability to decrypt, if it's one of the weirder types of assistance demands that we've been talking about, don't comply, don't agree to comply, tell law enforcement that you need to talk to your lawyer, and then call up that lawyer who's experienced in government demands that you by now have, right? On top of that, we've gone through why this is a really unsettled area of the law, and there are a lot of areas in novel assistance orders where the law almost certainly, there's almost certainly no legal mandate for you to provide the assistance that's being requested. Burden may provide a solid ground for pushing back depending on the law, such as under the All Writs Act, depending what the law is that's being cited. That includes money, engineering time, potentially damage to your business's profits, to your business reputation and goodwill. Think about how many accounts are impacted. That can increase burden. Lavabit, as said, would have to have had to turn over its SSL keys. That would impact all of its users. And if complying would disable the entire service, as in the OnStar type case, that might make the order unenforceable as well. You can also think about whether there are any less intrusive or less burdensome alternatives that are more feasible to you that you could propose as a sort of counter-negotiation tactic. And think about how strong the legal arguments are on your side and on the government side, because you need to choose your battles. Not every order that you get might necessarily be worth pushing back on, and if you lose, it's possible that you're not just going to have a bad outcome for yourself, you're going to make bad law for everybody else. And in determining whether or not you should push back, we realize that this is not necessarily a one-size-fits-all kind of a recommendation. The legal arguments you have in front of you might vary. You may have differing resource levels than Apple, the richest company in America. You may have relationships with law enforcement that you want to protect. You need to be thinking about if I comply with this demand, am I going to get a whole bunch more demands in the future? If I push back on this demand, what will that mean for future demands from the US and from other jurisdictions? And you want to think about the PR effect of it coming out to the public that you complied with this kind of technical assistance demand or push back on it. Be aware, though, that if you do decide to comply, the law says that the government has to compensate you for reasonable expenses that you incur in providing technical assistance. So you get a little something for the effort. You got that going for you, which is nice. And so in conclusion, if you receive one of the novel technical assistance demands that we've discussed, figure out how to push back intelligently where you can. And please, please talk about the demands that you get if it's at all possible. As we've talked about, most of these things are under seal. We don't know whether we've been talking about things where the law is unsettled. It turns out there's dozens of under seal cases that we just don't know about. So please, if you get these demands and you have any ability to talk about them, please do so. That's our talk, and we're happy to take questions.
Thank you. We have like 5 minutes for questions, so please, feel free to line up and ask us stuff. I think we'll go from one side to the other, and then if you have other questions for us, you can give us some email. So let's start with the gentleman over there, please.
Hi, I like your talk, thank you. In the San Bernardino case, I remember part of the issue was that Apple's source code was proprietary, and the FBI did not have access to that in order to try to generate their own attack. Are you on better legal footing if your code is open source or available, or does it not matter?
I don't think it matters, because the issue is what can the government compel the third party to do. Of course, in both cases, they're free to take the code and try to build the exploit themselves, but the issue is what can they make you as a company that's not involved in the case do. Yeah. Over here.
Do you know of any case history about the use of canaries to disclose requests?
There's no case law on the warrant canaries. This is when you put something in your transparency report that says we haven't received any orders, so that when you get an order that says you can't tell anybody, you just don't put the canary in again, and then people are like, oh, they must have gotten an order because this thing disappeared. I don't think there's any case law on it, but it's a cool legal hack, and it is something that a number of companies do. Thank you. Yes.
Thank you. So I'm a little bit confused. I spent a couple of years as a Kalia subject matter expert a long time ago, and when you say companies, Kalia really only applies to carriers, correct?
It applies to companies that are identified, or businesses that are identified by the Federal Communications Commission as replacements for the telephone service. So the Kalia regulations say not just phone companies, but interconnected VoIP and internet broadband.
Right. So companies that provide software electronically or hardwired switching for communications purposes. Yeah. So probably aren't going to see someone knocking on the front door of just the average corporation because they pay a carrier to provide that service, right?
Correct.
Okay. So in terms of cooperation, that really would come at the carrier or service provider level.
Cooperation under Kalia comes at the carrier or service provider level.
Right.
And I talked a little bit about the Kalia statute because I think you can reason inversely from that statute about what the rules are that apply to information services that are not covered by Kalia. Mm-hmm. And information services that are not covered by Kalia nevertheless can be subject to technical assistance demands under either the Pen Register statute, the Wiretap Act, or the All Writs Act.
That's it. Right. Okay. Thank you.
Yeah, thank you. Thanks for clarifying. Sometimes these things are complicated, and I'm glad you asked that, so it's really clear. Yeah.
Yeah. Thanks for doing this talk. This was really helpful. The thing I'm confused about is a lot of these laws seem to be not written for current day technologies, and as a result, like most of the outcome was it's not really clear. So is there any movement on writing laws for current day technologies, and so that it's more clear for people as to what they're actually supposed to do under law?
Well, there was a really terrible proposal by Senators Feinstein and Burr to basically kill end-to-end encryption as we know it and mandate backdoors into services that died a well-deserved death. There have been various state-level requirements for that as well, or not requirements, but proposals for that as well. To date, nothing has really been passed. There's also been a couple of different attempts to update ECPA that keep getting pretty far, and then that's the Wiretap Act and Pen Register Act we talked about that get kind of far and then just sort of die. But like we were talking about, the Aldrich Act is from 1789. It's really old. You're absolutely right, we don't have a good legal regime for this. So there have been some haphazard attempts, but nothing has really been modernized.
I would just add that in the civil liberties world is sort of a view, like if you think that you can get good law through legislative enactments still today with this Congress, then people want to propose laws. But if you think that that's kind of a dead end, then really the area to work in is to litigate against these demands in the courts as they come up and get the common law or the case law surrounding it to basically limit what the technical assistance is and make it more clear.
Great. Thank you.
Yeah, thank you. I think this is going to be our last question. Yes, okay, last question, please, over here.
So thank you for doing this talk. In reading the automotive telematics carrier case, my understanding was their argument was that there was a safety of life issue and a potential breach of contract issue between them and their customers if that device was tied up feeding audio to the government when somebody drove into a tree and it couldn't call an ambulance or it couldn't call their monitoring center. My guess is situations like that are going to be increasing with all these embedded devices. Did that argument on the part of the telematics vendor carry any more weight, or was it really just kind of not unobtrusive and that got caused the ruling to go the way it went?
Yeah. You mean in the OnStar case?
Yeah, well, it wasn't OnStar. It was probably ATX.
Yeah, we don't know what it was. So, yeah. Do you want to?
I mean, I think I don't recall off the top of my head what the other arguments were that the court actually addressed, but the argument that won the day was this statutory language that says that there has to be a minimum of interference. If it completely disables the service, then irrespective of what your contracts are with your customers, it's still a standalone argument to say, look, if our 911 or whatever does not work when this particular device has been converted into a surveillance and eavesdropping device, then that was found sufficient by the Court of Appeals.
Yeah. I mean, I think, first of all, I can't see you, but I know who you are because I recognize your voice, so thanks for coming. The issue in that court is in that case kind of flows over into the Lavabit case, which is what is the kind of interference we're talking about here? In the car case, the interference was substantial. It was like, 911 won't work, this service doesn't work, if they hit a car, they'll die, and we will be liable. They didn't want to allow that. But would there be this right kind of interference to say, no, you can't make us do this under the statute, when Lavabit says, my service is secure email, and I'll still be able to serve email, but it won't be secure if you get my private key, and that's the kind of interference. Or would it be something like reputational harm, where, say in the Apple FBI case where Apple says, if we do this for the US government, all our foreign customers are going to abandon us. What exactly is the kind of interference that the statute contemplates? Or is it the security ecosystem overall? And the answer is we don't know, but companies are starting to make all those arguments. It's not just engineering, it's not just the product won't work, but it's, more than that too.
Thank you.
Thank you.
Thank you, and thanks to everybody for coming. We enjoyed it. Hope to hear from some people.